February of 2020. And I'm grateful for that opportunity, and it's very good to see everyone face to face and be able to meet together in person again. Ms. Bohannon, would you please call the roll?
Fred Berry.
Present.
Anthony Harris.
Here.
Tanya Haynes Scales. Present. Gain Hill, sorry. Clark McKinney.
Here.
Scotty Porsche.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Ms. Bohannon. At this time, we'll entertain a motion to adopt the agenda as presented or to amend it as necessary.
Motion we approve.
Second. We have a motion by Mr. Harris, a second by Mr. Rahm. Any other discussion? All in favor, say aye.
Aye.
All opposed? Motion carries. You have your minutes as a part of your packet today. If you'll take a moment to review those, and then we'll entertain a motion to approve the board meeting minutes for our March the 9th meeting or to amend them as necessary.
I'll make a motion to approve as presented.
We have a motion by Mr. Berry to approve as presented. Do we have a second?
Second.
We have a second by Mr. Harris. Any further discussion? Not all in favor say aye.
Aye.
Opposed, like sign. Motion carries. Before we enter into our legal report this morning, we have a special guest that I would like to introduce. Mr. Alex Martin is with us this morning. Mr. Martin is the Assistant Commissioner of Regulatory Boards for the state of Tennessee. So, Mr. Martin, we welcome you to our meeting, and we invite you to address the board at this time.
Thank you, Mr. Chairman. Great to be here this morning, and great to see so many friends and colleagues on this board. I think I've had the pleasure of meeting a few of you, but have probably spoken on the phone with most everybody on this board. So before I joined the department in January, I had the pleasure of working in the governor's office for the past 2 years, and in that role, I had the opportunity to recruit and vet folks and ask them to serve on boards just like this one. And so our board members hold a special place in my heart. They play a very, very important role in helping us with our mission to protect the public. And so I certainly appreciate that, and great to see so many of you this morning. I want to make a couple remarks just about Robert and his team. So I've been on the job for about 5 months now, and I would just say from my perspective, this board couldn't ask for a better team. Robert is he's always paying attention to detail, and as you know, this subject matter that this board is often dealing with can be sensitive. It can be very personal to folks, and Robert has such knowledge and guidance to me over the last 5 months that I've just come to deeply appreciate. And so I just want to say here publicly, very, very grateful for him, and I want to make that very clear to this body. So thank you to Robert and all that he does. It's been a really exciting time for us. Obviously, a lot has gone on, but it's a very, very crucial time for the division. A couple pieces of legislation have passed this previous legislative session that are going to change things for our division. We're really excited and happy about that. I'm sure most of you were familiar with the modernization bill and some of the changes that's going to bring to our division. So very exciting time for us. I'm very grateful to be in this role. And Mr. Chairman, as you mentioned, it's good to have you all back in person. This is my first in-person board meeting as well. So planning on hanging out and learning a little bit, taking some notes of my own, and thank you for having me this morning. Thank you.
Thank you, Mr. Martin. At this time, we'll ask Ms. Bendale to present our legal report.
Mr. President, I need to recuse myself from the legal report, please.
The record reflect that Mr. Harris has recused himself from the legal report this morning.
Morning, board members. Nice to see you all back. Turning to the legal report, we're going to look at item number 1, which is complaint 2021-002491 against the funeral director. This was an ex-employee complaint alleging unprofessional conduct by the respondent. The complainant alleged that the respondent's employee chased them down and tried to hit their car and shoot them. Additionally, the complainant alleged that the respondent had tried and forced the complainant to be intimate. This complaint was sent for investigation dates due to the nature of the allegations. And in March 2021, a board field investigator interviewed and obtained documents from the respondent. The complainant was contacted multiple times via email, but failed to provide a working telephone number or address. Per the investigation, this matter appears to be a domestic complaint.
And Dale, are you aware of any criminal charges that may have been filed regarding this matter, or?
I am not. The investigator did ask, and it appears that no criminal charges were filed. Per the investigation, these two individuals were domestic partners. They had lived together for a period of 3 years.
I'll make a motion that we approve, council's recommendation for a letter of warning.
We have a motion.
And a second.
Mr. Berry. Second, was that you, Mr. McKinney?
Yes, sir.
I have a question.
All right, we do have a question.
Mr. Berry said something about a letter of warning. I thought it was for a recommendation of closure. Did I mishear you, Mr. Berry?
I did say, am I looking at it wrong?
Recommendation was for closure from legal.
Let me amend that then. Sorry about that. I must have skipped over one. Yeah, for closure.
All right, so Mr. Berry is amending his motion to recommend closure, to agree with legal's recommendation. Mr. McKinney, are you agreeable to that?
Yes, sir.
All right, so we do have an amended motion and a second. Is there any further discussion? Not all in favor, please say aye.
Aye.
Opposed, like sign. That motion carries.
This is a complaint based on an inspection of the respondent establishment. During the inspection, the representative discovered that a general price list indicating that a price match guarantee discount would be given on pre-need and at-need funeral arrangements. The representative indicated that the respondent informed them that the wrong general price list was provided and that the issue has been corrected. The representative further indicated that they were able to locate a GPL in the arrangement in business offices that the discount on pre-need funeral arrangements did not appear on. The respondent did respond to this complaint, and they indicated that a mistake was made by giving the representative an old price list, but that mistake was immediately corrected. And the respondent states that the general price list does not contain any language indicating that pre-need discounts are available. Legal's recommendation to do a letter of warning for this one.
Dale, does the department have documentation of that price list?
They do. It was provided with the
Motion to approve recommendation.
We have a motion by Mr. Rahm to approve council's recommendation for a letter of warning. Do we have a second?
Second.
We do have a second by Mr. Berry. Any further questions or discussion? Not all in favor of the motion, please respond by saying aye.
Aye.
All opposed, like sign. Motion carries.
Item number 3 is complaint 2021-01-2011 against a funeral establishment with some disciplinary history. This is a consumer complaint alleging unprofessional and fraudulent conduct. The consumer states that they were asked to sign a credit charge and contract multiple times via DocuSign. The respondent did respond to the complaint, and they indicated the following: that the contract needed to be signed by the consumer, who was the contract payer, and also by the legal next of kin, that the contract and the credit card forms were sent via the contract system, that the consumer signed the contract and then it was sent to the next of kin, but the system did not allow signatures after 48 hours, that the contract was resent to get signatures, but that the contract was not signed by the consumer. It was discussed with the consumer that the contract would be sent to them, but a contract with a balance due was accidentally sent. The respondent indicated that they spoke to the consumer, clarifying the mistake, and that a contract with a zero balance was resent. And lastly, the respondent states that the consumer did not sign the contract and they did not hear anything until the complaint was received. It's legal's recommendation to close this complaint.
Motion to approve recommendation.
Motion by Mr. Rahm to approve legal's recommendation for closure. Do we have a second?
Second.
We have a second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Item number 4, number 5, 2021-04531 establishment, 2021-0 and expired. This was a complaint based on an inspection in January 2021 of the respondent establishment. During the inspection, the representative discovered that the funeral director's license for the respondent funeral director had expired on June 30th, 2021, and was not renewed at the time of the exam, during which the respondent funeral director conducted services and acted as the establishment manager. The respondent responded to the complaint and apologized for the oversight. The respondent stated during the expiration period that they were dealing with a life-altering health situation, and the respondent indicated it was never their intent not to renew, and it was a complete oversight. Its legal recommendation. Disciplinary.
Dale, does the board have documentation of life-altering?
The documentation was explanation, explaining that they were hospitalized around the time.
I move to accept council's recommendation.
A motion by Mr. McKinney to accept council's recommendation for the funeral establishment and the funeral director. Do we have a second?
Second.
Mr. Porsche? All right. We have a second by Mr. Porsche. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Item number 6 is complaint 2021-01-7141 against the funeral director with no disciplinary history. This is a consumer complaint alleging unprofessional conduct. The consumer stated that the respondent was contacted regarding a simple cremation, but that the respondent arrived to remove the deceased and informed the wife of the deceased that they were not going to assist her. The complainant states that the respondent was hostile and that the respondent reported the conditions of the home as unsafe, which was false. The respondent did respond to this complaint, and they indicated the following: that the respondent was contacted by the deceased wife regarding a cremation. The respondent indicates that no written or verbal agreements were made, but that they discussed potential payment plans or donations from the local church. The respondent stated that they were informed that a neighbor would be available to assist since no additional staff was available for a house call. The respondent states that when they arrived at the residence, they expressed concerns with the condition of the ramp and inspected additional doorways. They were too narrow. The respondent states that they did not speak to the deceased wife except to say hello. The respondent states that they inquired about the neighbor's assistance as the deceased needed to be carried out the back door to be placed on a stretcher, so that the respondent was informed that the neighbor would not be assisting. The respondent also stated that they had to assess the situation and determine that they would not be able to safely remove the decedent. The respondent stated that the contact information for a funeral home that could better assist the family was sent to the complainant, and that the family ultimately ended up using that funeral establishment. And lastly, the respondent denies the allegations that they were hostile at any point. It's legal recommendation to do a letter of warning.
Dale, have we heard this complaint before? All sounds all too familiar about getting to the house and the ramp for steps not being suitable and having to, maybe I dreamed it. Like we had.
This particular funeral director doesn't have any disciplinary history, and as I was reviewing the complaint, it wasn't familiar to me. Possible before.
I'm sure Mr. Gribble would have memory of it, but it certainly sounds awfully familiar.
Might be a similar one, but not against this particular last name.
When an investigation takes place and the respondent gives their information, is that just somewhat consolidated and paraphrased for our information, or how is that information?
The information, it's, they responded to the complaint, and I didn't necessarily paraphrase, those are their words, but I just condensed.
I guess if a letter of warning was going to be given, is that based on the fact that this body would believe that the funeral director should have been better prepared when he went to the home? Would that be the basis of the letter of warning? Yeah, or anybody on the board that would want to comment to that, but.
That was legal basis when they recommended the letter of warning that they appeared.
It is based on not being prepared. I'll make a motion to accept recommendation of council then.
A motion by Mr. Berry to accept council's recommendation for a letter of warning. Do we have a second?
Second.
Second by Mr. McKinney. Any other discussion? All in favor, say aye.
Aye.
Opposed? Aye. You have one vote in opposition. Motion passes.
Item number 7 is this was based on an inspection of the respondent establishment. Discovered that the respondent September 3rd not renewed at the during which the respondent had a valid license. The respondent did respond to this complaint. The respondent indicated that they were relying on the website to time to renew. The respondent acknowledges that they should have never relied solely on the website, but they were dealing with the effects of the pandemic and personal health issues as well. It's legal's recommendation to do an authorization for a formal hearing and authorize a civil penalty of $250 via consent order.
The website, I presume they're referring to the core.tn.gov
They are.
website.
They did provide documentation. It was time to renew.
So the respondent is indicating that the website was not letting them know it was time to renew?
They appeared to rely on the website. Mr. Gribble they are also mailed notice that it's time to renew. And I believe if they were to go and the date.
The website was not listing any incorrect information, and there is no automation that the website's going to send notification.
Just from my understanding is that maybe there's been updates to core where it used to give you like time to if you hold more. Discovered that
I'll make a motion to accept your recommendation.
We have a motion by Mr. Berry to accept council's recommendation for a formal hearing and a civil penalty of $250 against the funeral establishment. Do we have a second?
Second.
Second. Force. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Number 1871 against an establishment. Disciplinary history. This is a similar set of facts. A board field representative performed an inspection of the respondent establishment in January. During that inspection, the representative discovered that the respondent's pre-need seller license had expired on September 30th, 2020, and was not renewed at the time of the exam, during which the respondent had executed 40 pre-need funeral contracts without a valid license. The respondent responded to the complaint and apologized for their oversight. It's legal's recommendation to do an authorization for a formal hearing and authorize a civil penalty of $250 via consent order.
Basically the same type of scenario, just several more pre-need.
Yes, and based on the fact that this respondent has no disciplinary history, that is why that civil penalty reflects a similar amount, even though they did execute more contracts.
Here's the 250 is typically the consistent penalty fine for not renewal, whether it's an establishment or a pre-need seller's agent, unless there's some type of really compelling reason for the situation, correct? I'll make a motion to accept council's recommendation.
Motion by Mr. Berry to accept council's recommendation. Do we have a second?
Second.
We do have a second by Ms. Haynes. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Item number 9 is complaint 2021-01-9541 against an establishment with disciplinary history. This is a complaint submitted by an ex-employee who served as a manager of the establishment, alleging unprofessional conduct by the respondent. The complaint indicated that the respondent establishment has an infestation of rodents, and that the owner management has not taken the steps to mitigate and resolve the issue, and due to such rodents have caused physical damage to the decedent's remains. This complaint was sent for investigation, and in March 2020, a board field investigator interviewed and obtained documents from the various parties involved, as well as conducted an inspection of the respondent establishment. The investigation discovered several violations, including the following: that the respondent owner management was notified on multiple occasions of the rodent infestation, that an exterminator was hired to mitigate the issue. However, documentation indicates that access to the building by the rodents was not addressed in a timely manner, that 2 known decedents' remains suffered physical harm and damage due to infestation, that despite the warning from the ex-employee who was employed at the time, the respondent continued to use the preparation room despite the known risk of damage to remains, and continued to use the preparation room after the first decedent. Damage to the decedents by the rodents occurred during separate incidents and did not purport to use 14 after the following: authorize a civil penalty of $10,000 via consent order. An additional do the following: respondent must ensure that both families are informed of the instances and provide an affidavit from the representative stating that when they were informed, the family and the substance of that conversation within 30 days of signing the order. Additionally, the respondent must provide both families a full refund of all money received for the services and merchandise related to the 2 decedents, and they must provide proof of the refund and calculation within 30 days of signing the order. The respondent must cease and desist from using the preparation room facility for embalming or any other activity with dead human remains until such time the building is repaired sufficiently to keep out any rodents. They must provide an affidavit from the funeral home operator that the repairs have been made sufficient to keep out all rodents. They must provide a summary of all the work done to make repairs. And once the affidavit is provided, they will not use it until the funeral board executive director, in consultation with the legal counsel, are satisfied that such repairs are sufficient. In no case, a response by the board must be made within 30 days. They must also provide a monthly report for the period of 12 months from the time of entering the consent order from a licensed extermination company as to the presence or indication of any rodent within the embalming facility. Upon notification from the extermination company of any sign of rodent in the building, the respondent must immediately take safeguard precautions to ensure no damage by the rodents. They must maintain a continuous presence within the facility by an agent until such time that all remains are removed from the building, the latest being within 24 hours of such notice. Does the board have that?
With the preparation area being in such disarray, what was the condition of the rest of the facility when the inspection was made? Is it safe for the public, or?
My understanding
It's two separate buildings on the same property, actually. There's a separate facility for the funeral home and then a separate facility for the embalming facility.
Is that a preparation garage type area or just preparation, you know?
Or how to exactly answer that question? There's not a garage connected to the preparation room that we're aware of or know of. However, I think there is another structure adjacent that's used by the funeral home, or was previously used by the funeral home and maybe no longer presently used by the funeral home.
Well, does the cease and desist have to be approved by the board before that can be levied against the establishment?
we did send this for investigation immediately, and we did request that they stop using approval for a set. They delayed that approval. This would just
It was more of a request, that's a request from the inspectors to.
Well, this would be in a formal consent order, so it'd be, I guess you're kind of asking is, could we have suspended immediately, requested that? And we evaluated that at the time, and we came up with a plan of action for them to use a separate.
You do have the power to make
Yeah,
such a action if deemed necessary. Okay. I take it based upon the findings, at this time, the families were not notified that there had been the situation.
It is our understanding that one family was notified and the other family was not notified. I'm going to repeat that just for the record.
Okay.
It's our understanding that one family was notified and that the other family was not. So part of this consent order was that we need documentation via affidavit that both families were notified.
And they did wait 14 days before moving their preparation
they
room?
requested approval to use a separate embalming and preparation facility, and they delayed that by 14 facility.
I would almost, of course, I'd like to hear from the other board members, but, you know, I think a civil penalty of $14,000, being $1,000 a day, and then plus everything else that you have recommended, you know, if the rest of the board members agree with that. Well, I will, but I was kind of soliciting some more comments, I guess. Yeah.
They'll, I assume, a field investigator will revisit this facility physically to monitor the progress of these conditions and terms that have been laid out here, and they will communicate directly with Mr. Gribble.
You're correct. We're also requesting, as you see, that monthly reports from an actual extermination company as well.
Is that an extermination company that we contacted or that they contacted and have influence over?
We're requesting from a licensed extermination company. If there's something wrong with my mic, I apologize. We're just requesting that it be a licensed extermination company in the area that.
And it would be the respondent's responsibility to contact the exterminator. Okay. Okay.
Dale, do we know anything about the circumstances of the complainant's departure from the respondent establishment when they left that employment?
It's my understanding that they resigned. They brought these matters to our attention, and then they put in their formal resignation on the contract engagement.
I will make that in form of a motion that it be increased to $14,000, which is $1,000 a day. And then all of the other recommendations along with it.
Kenny has made a motion to amend legal's recommendation for a $14,000 civil penalty in addition to the other 4 terms that are listed in your legal report. Do we have a second to Mr. McKinney's motion?
Second.
Second by Ms. Haynes. Any further discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
Item number 10 is complaint 2021-02-0441 against an establishment with no disciplinary history. This was based on an inspection conducted in January 2021. During the inspection, the representative discovered that the respondent's pre-need seller license had expired on December 31st of 2020 and was not renewed at the time of the exam, during which time the respondent executed 7 pre-need funeral contracts without a valid license. The respondent did respond to the complaint and they apologized for their oversight. The respondent stated that they were unaware their license had expired and indicated that as soon as they found out about their license expiration, they rectified the situation. It's legal's recommendation to do authorization for a formal hearing and authorize a civil penalty of $250 via consent order.
Motion to approve recommendation.
Motion by Mr. Ron to approve council's recommendation. Do we have a second?
Second.
Have a second by Mr. Berry. Any other discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
Item number 11 is complaint 2021-02-141 1361 against the funeral director with no disciplinary history. This was a consumer complaint alleging that the respondent is advertising that they are a licensed funeral director. The respondent responded to the complaint and indicated that they are licensed. Per core, the respondent does hold a valid license, and the complainant did follow up and asked to withdraw their complaints based on this information. It's legal's recommendation to close this one.
Motion to approve?
Second.
Motion by Mr. McKinney and a second by Mr. Berry to approve council's recommendation. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
Item number 12 is complaint 2021-02-2931 against the funeral establishment with disciplinary history. This was a consumer complaint alleging unprofessional conduct. Specifically, the consumer states that a prepaid funeral plan was purchased from the respondent. The consumer states that after the decedent had passed away on March 21st, 2021, they contacted the respondent regarding the removal of the deceased and that the respondent was unresponsive to their calls. The consumer states that the decedent was arranged to donate his brain to MSA research, and the pathologist needed to be able to harvest his brain within 12 hours to make the donation. The consumer states that the decision was made to call another funeral home and that the respondent had yet to retrieve the decedent. The consumer states that the respondent has been unresponsive. The respondent's representative responded to the complaint and indicated the following: that the respondent does not have any record of the calls received related to the passing of the decedent prior to the one receiving the morning after, that the respondent met with the family on March 31st to finalize arrangements for the funeral and the burial, that the funeral service was held at the funeral home on April 2nd, and the decedent was buried the same day. The respondent is reaching out to the family to discuss any additional concerns they may have and to offer apologies. The consumer did provide a rebuttal indicating that they had left multiple messages for the respondent and that they were never returned. The consumer said the decedent was with another funeral home for over a week before they were contacted about making arrangements. It's legal's recommendation to do an authorization for a formal hearing and authorize the civil penalty of $500 via consent order.
Did the respondent utilize an answering service, or were these voicemails that were being left, the messages that were being left?
It's my understanding that the number listed for this establishment goes to the larger entity's voicemail, but that the voicemail machine indicates that it would be given to that establishment. And they indicated that they had tried to contact.
Did they change funeral homes or not?
They did not. The decedent was held at the other establishment, which legal was able to confirm for a week period because the consumer had a pre-approved plan with the respondent. So ultimately, the services were conducted.
Funeral home that held the remains for that week-long period, a related entity?
They were not.
Their family in this situation had charges for that week with the other establishment.
The family did not indicate whether or not there were charges. They just indicated that due to the time of retrieving other establishment, ultimately.
Not quite clear. So the following day after the initial call, the funeral establishment was contacted or they did return the call to the family?
So, from my understanding from the timeline provided by the consumer and also the respondent is indicating that they did not receive those voicemails that were left. I believe the decedent had passed away in the middle of the night. They're indicating they only received a phone call the morning after. They did not provide a timeline between that morning call until March 31st, when they indicated that that is when they first met with family. In March. So
That next day, was it already too late? The family had already made the decision to have their loved one?
Yeah, because from the consumer's complaint, they indicated that there would be that 12-hour period. From their complaint, they're indicating that the respondent did not return the call that morning. The respondent's only indicating that they received the call. They did not imply or indicate that they called that morning. As a rebuttal to this.
No explanation given as why they didn't return the call. Seems based that the respondent didn't give very, didn't respond what I would think would be in an adequate manner, nor really gave a good explanation to the investigators. I'll make a motion to accept your recommendation.
I have a motion by Mr. Berry to accept council's recommendation to authorize a formal hearing, with also authorization for a civil penalty of $500 by a consent order. Do we have a second?
Second.
Have a second by Mr. Porsche. Any other discussion? If not, all in favor say aye.
Aye.
Opposed? Motion carries.
Items number 13 and number 14 are against the funeral director with no disciplinary history. It's the same licensee. Similar facts, but I will read them both into the record. They're complaint 2019-100-731 against the funeral director. This matter was previously presented at the May 12, 2020 meeting. It was presented as follows: that this was a consumer complaint alleging that the consumer had arranged for her father's cremation in November 2019, and that as of the date of the complaint, they had not received the death certificates or confirmation that the father's remains had shipped. The respondent did not respond to this complaint, and legal was able to speak with the consumer, who indicated that they did receive their father's cremated remains. At the time, it was a recommendation to authorize a civil penalty of $500 onto the complaint. Legal did speak to the respondent, who is unaware that our records indicate that all mail was returned as undeliverable, and the respondent did indicate that they thought that by providing a response to a complaint filed against the funeral home, that they would automatically be used as a response to the complaint against them personally. The respondent did provide all documentation that they had previously provided a response to the funeral home. There was a complaint open against the establishment and the individual, and it appears that the individual provided a response to the establishment, who then provided a response to us, where it appeared in our records that the individual did not respond. Based on this information and the respondent providing all this additional documentation, as well as proof that the matter had been resolved to the satisfaction of the consumer, legal would like to close.
Question on, was it the return mail, was that addressed to the funeral director's home address, or?
It was directed to the home address. During this period, the funeral director was, I believe, moving out of state. But he did, like I said, document. Based on his disciplinary history, authorization.
Just a follow-up question, is it typical to practice that the notification would only go to the director's home residence, or does typically it go to the establishment that they're associated with as well?
It goes to the address on file, is my understanding from that as well.
Okay. I was just curious. I'll make a motion to accept your recommendation for closure.
Second. Motion by Mr. Berry and a second by Mr. Rom to accept council's recommendation for closure. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries.
And item number 14 is complaint 2020-001851 against the same funeral director with no disciplinary history. This matter was also presented at the May 12, 2020 meeting, and this was a consumer complaining alleging that the consumer had arranged for their mother's cremation and that they had not received the remains until late of November 2019. The respondent did not respond to this complaint as well, and legal was able to speak with the consumer in February of 2020, and they had indicated that they did. At the time, legal's recommendation authorizes a consent order at 500 complaints were presented back to amount. Legal has since spoken to the respondent, who indicated that they were unaware that there was an outstanding complaint. Similar set of facts and our records indicate that all mail was returned as undeliverable. And the respondent did provide a detailed response as well as documentation regarding the issues that the original complaint were promptly addressed and resolved. It's legal's recommendation to do a letter of warning for this one.
I assume that the consent orders in these cases were signed and that the civil penalties were paid?
They were not. So these are represents. So the original recommendation was to do those consent orders with civil penalties, and now the recommendation would be to close the matter and to do a letter of warning so that there will be a letter on file in case any similar matters arise in the future.
Thank you for that clarification.
And the board has the correct contact information
Correct,
on
yeah.
file now.
I made sure I'll correct contact. And that's kind of what this letter of warning would indicate, so that it's not formal disciplinary action, but it is a reminder to the respondent that all contact information and any complaints going forward must be addressed.
Just a comment. Under the summary, it talks about when it gives dates, it says like October 2019 and then late November. It seems like we really, to analyze that, it would be helpful to know exact dates on that, so you see exactly how long the delays were. Just a comment.
Okay, yeah, going forward, I can put the exact dates on the legal reports if that would be.
There was really no, but the respondent, there was really no really good explanation for these delays.
The respondent did provide a detailed explanation. It doesn't, the time period from October 2019 to late November 2019 is about a 4 week. So it, authorize a civil at the time we were back to back. Was the certificate summary that
I guess in my mind, I'm just trying to think through that, and if there was really valid reasons for the delays, and whether it's, you know, should we approve the recommendation letter of warning, or should it be a closure? That's what I'm kind of going through my mind. But I'm having a hard time really determining whether there was really valid reasons for the delay in the death certificate.
And Dale, are there any provisions in the laws, rules, regulations of this board that could create a situation for a licensee in the state of Tennessee where it might be a violation for them not to forward a new address or an active address
They're required.
to the board?
They are required under our rules and regulations to keep all of appears. Seems that there was a miscommunication.
Failure to provide your current contact information could in itself create a violation.
I don't know if I would have to look into it, or
Also seems like the establishment would know that this is also happening as far as the complaint, not only to the establishment, also to the director. It seems like the establishment would have been on top of that as well, wanting to make sure that that was handled appropriately.
as part of the letter of warning, based on this individual's lack of disciplinary history, I can provide that particular information indicating that all addresses and contact information must be provided within, I believe it's
I want to make a recommendation to accept your recommendation of the letter of warning then.
I have a motion by Mr. Berry to accept council's recommendation for a letter of warning. Do we have a second? Second by Mr. Ron. Any other discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
Before we move on, Mr. President, I have a question for Ms. Bendale. When the board is presented with recommendations that include authorization of a formal hearing and fines, is it possible for the board to receive the complete response from the respondent and not just a summary?
I believe, yeah, the board, I can provide the full.
I would like to see that happen so I can better make I'm not saying the summary is not correct, but I'd like to see everything.
I'd be happy to provide.
Okay.
Just as.
Sure. Absolutely. I'm very familiar with that.
Thank you, Ms. Bendale. Next item on our agenda is the Executive Director's Report. Mr. Gribble.
Thank you, Mr. President. Good morning, board members. Good to see everyone again today. The first item we have is the legislative report, and this is a report that's been sent to you, and we've looked at for the past few months. The bills that have traction are the administration bill, House Bill 0780, Senate Bill 0771. Pay the fourth speakers for their signatures. House Bill 0931. regarding alkaline hydrolysis and their facilities for those. It's passed, it's signed by the governor, it's been assigned public chapter by the Secretary of State. It's public chapter 0141, has an effective date of 4/13/21. And then House Bill 1181 and Senate Bill 0828, it has to do with the fetal remains that have been aborted to be buried or cremated. That was transmitted to the governor for his action on 4/27/2021. The other bills that are listed there, obviously the legislature is adjourned, so those did not pass during this session, but they'll be back in January, and things that were introduced this year can be acted on still next year. Licensee reports: a report of licenses administratively approved by the executive director pursuant to board authority for the period of March 6, 2021 through April 30th, 2021. You see a list of several establishments and then several individuals there and what type of license each one obtained or why they obtained them. Also, the closed establishment report. It's a report of consent orders that have been administratively accepted or approved by the executive director pursuant to the board authority, and these were as reported on the February 2021 and March 2021 regulatory board's disciplinary action reports, and have a list of the 3 funeral homes there, their location, the violation, and the civil penalty for those. No closed establishments for this time. And as far as complaints, we have, as of May 5, 2021, we had 21 complaints that were regarding a funeral director and/or embalmer, and 20 complaints that were open regarding an establishment, for a total of 41 complaints. That concludes my report. I'll be glad to answer any questions you might have.
Any questions for Mr. Gribble? Thank you, Mr. Gribble.
Motion to approve.
We have a motion to approve by Mr. McKinney, a second by Mr. Rom. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Approval of license applications. Do we have any individual licenses? Do we have any establishment licenses? There being none, or is there any new business that needs to be brought before the board today? If not, we will entertain a motion to adjourn.
So move.
We stand adjourned at 10:58 a.m.